Welcome back to the deep dive. And for those of you really getting into the weeds of HR, especially if you're gearing up for your SPHR certification, today's deep dive is critical. We're talking conflict resolution and alternative dispute resolution, or ADR. And look, this isn't just theory. It's really about giving you the strategic thinking and, the practical tools you need to turn those inevitable workplace challenges into, well, opportunities for growth and staying compliant.
Yeah, that's exactly right. Because let's face it, the modern workplace, it's complex. Conflicts will happen.
Absolutely. It's a given. The real test isn't stopping conflict altogether. It's how effectively we deal with it when it comes up.
Right. And that choice, it impacts, well, pretty much everything. Employee engagement, retention, legal headaches, the whole vibe of the organization.
So consider this your shortcut, your focus guide to mastering these ideas for the SPHR exam, but also, importantly, for applying them as a strategic leader out there in the real world.
Precisely. And we've pulled together a pretty solid stack of sources for this. We're talking academic research, government resources, think Department of Labor, and some really good HR-specific guides. Our mission today, simple. Boil it all down for you, get to the most important stuff. We'll unpack the key terms, navigate the legal stuff that keeps changing.
Always changing.
Yeah, always. We'll look at HR's strategic part in all this and give you some actual techniques you can use. The goal is for you to really get this stuff so it sticks, for the exam and for your day-to-day.
Okay, let's start building that toolkit then. We hear ADR a lot, but what is alternative dispute resolution, really? Yeah. What makes it so important for HR?
Okay, so at its heart, ADR is basically any agreed-upon way to solve a dispute using a neutral person or method outside of going to court.
Outside the courtroom. Got it.
Yeah. And the key things, the hallmarks HR needs to grasp are these. It's usually voluntary, it's flexible, often way faster, it's confidential, and it allows for more creative solutions sometimes.
Creative solutions?
Right. It's about stopping things from blowing up into a big legal fight, which, saves time, money, and maybe even relationships. That's a huge win.
Makes total sense. It's about finding that common ground before everyone digs in their heels legally. So if ADR is the big umbrella, what are the specific tools under it? Like, where do we start on the spectrum? Maybe from least formal.
Right. We start with negotiation. That's really the foundation.
Negotiation. Okay, so that's the direct back and forth, right? Just the parties involved, no third person stepping in. They often call it preeminent because, well, the people in the dispute keep all the control over how it goes and what the outcome is.
Exactly. It's just them trying to work it out.
But are there different ways to negotiate? Different philosophies, maybe? And where does that matter for us in HR?
Oh, absolutely. And knowing these different approaches, that's strategic for HR. There are basically two main styles you see. First, there's interest-based bargaining. You might also hear it called integrative or win-win.
Win-win, okay.
Yeah. Here, you're trying to get past the fixed positions like, I need this specific thing, and dig into the why. What are the underlying interests, the needs, the concerns driving each side? The goal is to bake a bigger pie. Find ways for both sides to gain something valuable.
Like that orange story.
Exactly like the orange analogy. Perfect.
Yeah.
Two people fighting over one orange. Positional thinking. They just cut it in half. Maybe neither is happy. Interest-based. You ask why they want it. Oh, one needs the peel for baking, the other wants the juice. Boom. Both get exactly what they need. Win-win.
Okay, so that's interest-based. What's the other kind?
The other is positional bargaining. This is more like distributive. Think haggling. Each side plants their flag, I demand X amount, or I won't accept less than Y, and they bargain over those fixed points.
This is more like a fight.
It can be. It tends to be more adversarial, often leads to just splitting the difference, a compromise where maybe nobody's truly satisfied, or even just gridlock, because you're not really addressing those deeper needs. So for HR, pushing for that interest-based approach, that can really change the game in how people handle disagreements. Shift it from conflict towards, collaboration.
That's a really powerful distinction. Focus on the why, not just the what. Okay, but what if direct negotiation just isn't working? Maybe tensions are too high or the relationship's already strained. I guess that's where mediation comes in.
Precisely. Mediation is that next step. It's a structured, still voluntary process where you bring in a neutral third party, the mediator.
Okay, a neutral helper.
Exactly. And this is crucial for HR. The mediator helps them talk, helps them explore options, find common ground, but they do not decide the outcome. Their job is to facilitate the conversation, not impose a solution.
So the power stays with the parties involved.
Absolutely. It's non-binding. Any agreement has to come from them, mutually agreed upon. The big advantages here, especially in a workplace, it can help save working relationships, and it really pushes for collaborative problem solving, not just winning or losing.
Are there different types of mediation?
Yeah, there are typically three main models people talk about. And for HR, the real insight is knowing which one fits the situation. First, there's facilitative mediation. Here, the mediator mostly structures the conversation, helps clarify things, but the parties totally control the outcome. Great for preserving those long-term relationships.
Okay, party-driven.
Then you have evaluative mediation. This is where the mediator, who's often an expert, maybe a retired judge or lawyer, gives their opinion on the strengths and weaknesses of each side's case, maybe even suggests settlement terms.
More directive.
Right. It can be faster, especially if legal points are key, but there's a risk parties might feel judged or pushed. And finally, transformative mediation. This one's different. The focus isn't just settling this dispute. It's about empowerment and recognition, helping the individuals understand each other's perspective better, maybe even transforming the relationship itself. It's deeper work.
Wow, okay. So choosing the style of mediation is strategic too.
Okay.
Got it. Now let's climb another rung on that formality ladder, arbitration. This sounds more like a mini-trial, right?
It does have that feel. It's generally the most formal of the ADR methods. You have a neutral arbitrator or sometimes a panel of them who acts like a private judge. They hear evidence, listen to arguments.
Like presenting a case.
Exactly. You present evidence, maybe have witnesses. Discovery gathering information beforehand is usually more limited than in court, though. And the arbitrator follows rules the parties agreed on, often more flexible than strict court rules. But here's the absolute critical point for anyone studying for the SPHR.
Okay, leaning in here.
It's the difference between binding versus non-binding arbitration. This is huge. Binding arbitration means the arbitrator's decision, the award, is final. It's legally enforceable in court, and crucially, the parties usually give up their right to sue in court or appeal the decision. This is pretty standard in many employment agreements these days.
Okay, final answer. No do-overs.
Pretty much. Non-binding arbitration, though. The arbitrator's decision is just advisory. It's like a recommendation. Either party can reject it and say, nope, we're going to court, or try something else. It only becomes binding if both sides explicitly agree to accept it after the decision is made. HR pros have to know which type they're dealing with. It changes everything about the outcome's finality.
That finality in binding arbitration sounds efficient. I remember seeing some stats, like from the AAA, the American Arbitration Association. They said employment cases often wrap up in arbitration in, around 16 or 17 months? Yeah. Compared to like 2 or 3 years in court, that's a massive difference.
It is. The speed and potential cost savings are major drivers for using arbitration.
But wait, if it's so efficient and final, why wouldn't everyone just use binding arbitration for everything? Why bother with mediation or risk going to court? What's the downside of that finality?
That's a great strategic question. While arbitration is faster and usually cheaper than court, that finality comes at a cost. The parties give up control over the outcome. It's the arbitrator deciding, not them. It can feel less collaborative, potentially more damaging to relationships than mediation. Plus, it's private, less transparent than public court records.
Okay. Trade-offs.
Always trade-offs. So HR has to weigh that need for a quick, decisive end against maybe wanting a more collaborative solution or preserving a working relationship. Arbitration is a powerful tool, but it's for specific situations, not a one-size-fits-all answer.
Right. Choose the right tool for the job. Okay, so we've got the methods, negotiation, mediation, arbitration. But just having the tools isn't enough, is it? We need to understand the rules of the game, the laws and regulations in the U.S. that shape how HR can actually use these ADR tools. Where do we start with the legal framework?
The absolute foundation, the bedrock, is the Federal Arbitration Act, the FAA. It goes way back to 1925.
1925.
Yeah. And it's fundamental because it basically tells courts, if there is a valid written agreement to arbitrate a dispute, you must enforce it. Courts have to enforce the agreement and the resulting arbitration award. There are exceptions, like basic contract offenses, but the FAA reflects a really strong national policy in favor of arbitration.
Okay, so the law strongly supports arbitration agreements, but hasn't that caused some friction with other laws that protect employees? Like the National Labor Relations Act, the NLRA from 1935, that protects workers acting together, right? Concerted activity.
Exactly. The NLRA protects things like unionizing or employees joining together to complain about wages or conditions. And yes, there was significant tension between the FAA's push for individual arbitration and the NLRA's protection of collective action.
So how did that shake out?
It went all the way to the Supreme Court. The landmark case was Epic Systems Corp v. Lewis in 2018. And the court essentially said the FAA wins out in this context. Employers can enforce agreements that require employees to resolve disputes like wage and hour claims through individual arbitration, even if that agreement includes a waiver of class or collective actions.
So you can be required to arbitrate alone, even if the NLRA generally protects group action.
For those types of claims covered by a valid arbitration agreement, yes, according to Epic Systems. Now, the National Labor Relations Board, the NLRB, clarified things a bit later. They said employers can make signing these individual arbitration agreements a condition of employment even for existing employees. But, and this is important, they can't retaliate against employees for engaging in other types of protected concerted activity, like discussing wages or trying to organize a union. So the NLRA isn't dead, but its power regarding class action waivers and arbitration agreements was significantly limited by the FAA as interpreted in Epic Systems.
That's a really critical point for HR to understand.
Mm.
Okay, moving on to another huge area. Discrimination. We have Title VII of the Civil Rights Act of 1964, which bans workplace discrimination based on race, color, religion, sex, national origin. How does Title VII interact with ECR, and is there anything new HR needs to know here?
Right. Title VII itself isn't an ADR law, but it massively shapes how disputes are handled because employers have a duty under Title VII to prevent and fix discrimination. Now, discrimination claims under Title VII can generally be subject to arbitration if there's a valid agreement, but the process has to allow the person to effectively vindicate their statutory rights.
Okay, so arbitration can cover discrimination claims,
But there's a massive recent change, a real game changer. It's the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2022, the EFAA.
EFAA. Got it. What does it do?
It directly amends the FAA, and it says that any pre-dispute arbitration agreement, meaning one you signed before a dispute arose, is unenforceable when it comes to disputes involving sexual assault or sexual harassment that are filed in court.
Whoa. So if someone experiences sexual harassment and wants to sue, an old arbitration agreement can't force them into arbitration instead.
That's exactly right. For those specific claims, sexual assault and sexual harassment, the person making the claim gets to choose. They cannot be forced into arbitration against their will based on a pre-dispute agreement. This is a huge carve-out from the FAA's general rule and a non-negotiable compliance point for every HR department.
That is huge. So the legal landscape is definitely not static. HR really needs to stay on top of these changes. Which brings us squarely to HR's role. Beyond just knowing the rules, what's the strategic part HR plays in managing conflict?
It's really multifaceted. HR acts as a neutral facilitator, an administrator, and a strategic leader in this space. First off, neutral facilitation and mediation. HR can directly guide parties toward a resolution, staying impartial, or arrange for external mediators. It's about balancing empathy with making sure the process is fair.
Okay, guiding the process.
Second, internal investigations. When there are serious allegations, harassment, discrimination, other misconduct, HR have to step in and investigate. This means being thorough, fair, objective, gathering facts, interviewing people, and then recommending what should happen next based on policy and law.
The fact-finding role.
Sure.
Crucial.
Yeah, absolutely. Third, HR is the architect and guardian of policy. We design and enforce things like grievance procedures, open door policies, maybe formal ADR programs. And critically, we ensure managers apply these policies consistently and legally. Think progressive discipline, for example. Consistency is key to fairness and defense.
Right. Building the framework.
Fourth is training and capacity building. HR needs to equip managers and even employees with skills like active listening, how to give good feedback, basic negotiation, maybe de-escalation. If managers can handle small issues effectively at their level, fewer things blow up and land on HR's desk.
Empowering others. Makes sense.
And finally, and maybe most importantly, HR shapes the culture and psychological safety. Are people actually comfortable raising issues? Or are they afraid they'll be punished? HR promotes safety through things like whistleblower protections, maybe anonymous reporting channels, and by modeling respectful communication themselves. When HR handles conflict well, it builds trust. That directly impacts engagement and keeps people around.
That's a really holistic view.
Yeah.
HR isn't just reacting to problems, it's actively building a system and a culture to manage conflict constructively. Prevention, facilitation, policy. It's all connected. Okay, let's get practical. Negotiation tools, what should HR have ready?
Okay, some key tools. First, know your BAT&A, your best alternative to a negotiated agreement. What's your plan B if talks fail? Knowing this gives you power, Don't negotiate without it.
Your walkaway point. Got it.
Second, identify the ZOPA, the zone of possible agreement. Where do your acceptable outcomes overlap with theirs? Is there actually a space where a deal can happen? If your minimum acceptable outcome is higher than their maximum, you've got a negative ZOPA. No deal possible unless someone moves.
Finding that sweet spot.
Right. Then think tactics. Integrative versus distributive. Always try for integrative first, that win-win approach. Share info, look for trade-offs, brainstorm multiple options. If you hit a wall, then you might shift to distributive tactics like anchoring with a strong first offer, or maybe just splitting the difference but know that can strain the relationship.
So create value before claiming value.
Exactly. And underlying all of this, active listening and framing. Really listen to understand, not just to reply. Show empathy. Paraphrase to confirm you get it. Use I statements, I feel instead of you did. And frame your proposals positively. Make it easier for them to say yes.
These sound essential for any tough conversation, really. But what about when things are already heated? Before you even get to formal ADR, sometimes you just need to cool things down.
Yeah.
De-escalation, right? Any quick wins there?
Oh, definitely. De-escalation is huge. Sometimes simple things work wonders. Active listening and empathy, just letting someone vent, showing you hear their frustration, can lower the temperature dramatically. Establishing ground rules up front for respectful talk can keep things civil.
Like no interrupting, no personal attacks.
Exactly. Using collaborative language focusing on the issue or the problem instead of you versus me helps depersonalize it. And don't underestimate the power of a timeout. Just saying, okay, let's take 5 minutes to cool off can be incredibly effective when emotions are running high.
Hit the pause button.
Right. And sometimes just having HR step in early as a neutral listener, not even mediating formally yet, but just providing that third-party ear, can stop things from spiraling. Think of these as your emotional first aid kit.
Emotional first aid, I like that. Okay, so we have all these tools: negotiation, mediation, arbitration, plus de-escalation. How does HR decide which one to pull out of the bag for a specific situation?
It's all about context, the nature of the dispute, and what you want to achieve. Informal negotiation. That's your go-to, your first stop for everyday stuff, minor disagreements. Your open-door policy lives here.
Start simple.
Right. If that fails, or if it's more complex, maybe deep personality clashes, some types of harassment claims where you really want to try and mend the working relationship if possible, then mediation is often the best bet. It's structured but flexible, non-binding, focuses on communication and finding mutual solutions.
When relationships matter most.
Exactly. Now, arbitration comes in when you need a final binding decision. Maybe it's required by a union contract for grievances, or you have a serious statutory claim where the parties want finality, or it's mandated by an employment agreement for specific types of disputes. It's more formal, less about relationship repair, more about resolution.
And litigation.
Litigation, going to court, is generally the last resort. You go there if you have to, maybe because of those EFAA exceptions for harassment claims, or if all other ADR methods have failed and there's no other path to resolution. The strategic piece for HR is accurately diagnosing the situation and picking the approach that best fits the specific circumstances, the company culture, and of course the legal requirements.
Makes sense.
Yeah.
And when HR gets this right, when they use ADR strategically, what's the ripple effect? How does it impact the bigger picture engagement, keeping good people, managing risk?
The ripple effect is huge. First, engagement, retention, and employer brand. When employees feel conflicts are handled fairly, respectfully, and quickly, it builds massive trust and boosts morale. People are more likely to stay, more likely to be engaged, and it makes the company look good as an employer. Unresolved conflict. It tanks morale, kills productivity, and drives people away.
The just workplace effect.
Exactly. Then there's risk management and compliance. This is huge, too. ADR, especially mediation, is typically way cheaper and faster than going to court. We're talking maybe 10% of the cost sometimes. It's also usually confidential, which protects the company's reputation. Arbitration offers finality, limiting appeals, and ongoing legal battles. But, and this is key for compliance, HR must design these programs carefully, make sure arbitration clauses are legally sound, comply with the latest laws like the FAA and EFAA, and don't improperly try to force arbitration for claims where it's now prohibited, like those EFAA cases. Documenting everything, tracking outcomes, that's crucial for showing the process works and meets legal standards.
Right, you need the data. Which brings us to metrics. How do you actually measure if your ADR program is working? And thinking about the SPHR exam, what are some key numbers or pitfalls candidates need to nail?
Right, metrics matter. Even here, you need to show the value. So Track cost comparison. What did mediation or arbitration cost versus what litigation likely would have cost? Show those savings, like mediation saving potentially 90% or arbitration being months faster than court. That's powerful ROI data.
Show me the money saved.
Exactly. Track the resolution rate. What percentage of disputes get resolved at each stage? Like the AAA says something like 76% of employment arbitrations settle before the final award. That shows the process encourages settlement. Measure time to resolution. How many days, on average, from complaint to closure? Faster is generally better. AAA mediation, for instance, averages around 114 days.
Faster resolution, happier employees, maybe?
Could be, which leads to tracking employee satisfaction feedback. Use surveys. Ask people if they felt the process was fair, if they felt heard, if they feel safer raising issues now. And also track the recurrence rate. Are the same types of conflicts popping up again and again? That might signal a deeper issue needs addressing.
Those metrics definitely tell a story. They show ADR isn't just nice to have, it's a smart business strategy. Okay, let's pivot to those SPHR exam gotchas. What are the common traps people fall into with ADR questions?
Okay, definitely some common ones to watch out for. First, confusing mediation and arbitration. This is fundamental. Mediator, facilitator, no power to decide. Arbitrator, judge, makes a binding decision, usually. Don't mix them up.
Facilitate versus decide. Got it.
Second, binding versus non-binding. Know the difference cold. Binding means it's final, enforceable, very limited appeal. Non-binding is just advisory. Parties can walk away. The implications are totally different.
Finality is key.
Third, misapplying legal precedents. This is tricky because the law changes. Remember EPIC systems? FAA generally allows class waivers for wage claims over NLRA objections. But then remember the EFAA. It specifically excludes sexual harassment assault claims from forced pre-dispute arbitration. You can't just apply one rule everywhere. Context and claim type matter.
Know the exceptions.
Exactly. Fourth, understand the scope of ADR clauses. Is this a grievance procedure under a union contract? Is it a voluntary mediation program? Is it a mandatory arbitration clause in an employment agreement? And what specific claims does it cover? Read the fine print. Fifth, don't confuse an HR policy with a contractual ADR agreement. A policy encouraging mediation doesn't have the same legal force as a signed arbitration contract. Enforceability is different.
Those are definitely things to drill down on. Okay, to help make all this stick, any handy retention tools, mnemonics, frameworks?
Yeah, a few simple ones can help. For negotiation, think BATS. Batane, your best alternative. Anchor, your starting position. Trade-offs, what can you give? And ZUPR, the zone for agreement. Run through that mentally before you negotiate.
Bats. Okay.
For the types of ADR, visualize an ADR ladder. Bottom rung is negotiation. Least formal, most control. Step up to mediation. Step up again to arbitration. Top rung is litigation. Most formal, least control. You generally want to stay as low on the ladder as possible.
Climb only when necessary.
Right. For managing the conflict itself, think iceberg. Like an iceberg, most of the real issues, the interest, the communication breakdowns, the lack of empathy, are hidden below the surface position. Focus on what's underneath.
What's below the waterline?
And for the legal and policy side, maybe the 4 C's of ADR. Check the policy contract. Is it valid, current? Consent. Is it voluntary or mandatory? Competence, are the neutrals qualified? And confidentiality, is privacy protected? Just a quick checklist.
Those are great. Bats, ladder, iceberg, 4 C's. Helpful handles. Okay, let's quickly test this with a couple of SPHR-style scenarios. Can you walk us through the thinking?
Sure. Let's take scenario 1. 2 engineers, Alice and Bob, clash over project credit. Bob wants a final decision from someone. Alice really wants to fix their working relationship. What's the best next step?
Relationship matters to Alice. Bob wants finality.
Right. The best next step here is likely mediation. Why? Because the core issue seems interpersonal, and Alice explicitly wants to restore the relationship. Mediation is perfect for that facilitated dialogue, focus on interests, non-binding, voluntary. Arbitration is too formal and adversarial at this stage. It might resolve the credit issue, but destroy the relationship. Negotiation might have failed already, so mediation fits best.
Okay, mediation to preserve the relationship makes sense. What about scenario 2? Maria wants to file a class action for unpaid overtime. The company points to her employment agreement, which has a clause requiring individual arbitration and waiving class actions. Maria says that violates the NLRA. What's the likely outcome?
Based on current law, the likely outcome is individual arbitration. This goes straight back to Epic Systems v. Lewis. The Supreme Court held that the FAA enforces these individual arbitration agreements, including class action waivers, even against NLRA challenges for these types of wage claims. So, unless there's some other specific defense to the arbitration contract itself, Maria would likely be compelled to arbitrate her claim individually, not as part of a class action in court.
So Epic Systems is the key precedent there. Those examples really show how you need to connect the concepts to the specifics.
Exactly. It's about applying the right rule or process to the facts presented.
Okay, wow. We've covered a lot of ground. We really did a deep dive into that HR conflict resolution toolkit. We looked at negotiation, mediation, arbitration, what they are, how they differ. We navigated that complex legal landscape, FAA, NLRA, Title VII, and that really important EFAA. We unpacked HR's strategic role way beyond just putting out fires, and we got some practical techniques and memory aids.
Yeah, and these concepts, they're not just exam fodder, they're absolutely fundamental for building workplaces where people feel treated fairly, where problems get solved productively, and where, frankly, everyone feels safer. HR's role as that impartial guide, the policy expert, the culture shaper, it's crucial for making that happen.
Totally agree. By really digging into these process differences, the legal details, how to apply them strategically, you're not just prepping for an exam.
Right.
You're building core leadership skills. Skills you absolutely need to handle some of the toughest, most sensitive parts of employee relations. So let me leave you with this thought to chew on. In a world that seems more polarized, maybe more litigious, how can we, as HR professionals, use this deep understanding of ADR, not just to fix conflicts after they happen, but maybe to fundamentally change how people interact at work? How can we use these tools proactively to prevent disputes from even getting started? What could psychological safety look like if we got really innovative with ADR strategies?
Yeah.
Something to think about.